sexual orientation is held to be a fundamental right. Someone is attracted, a man is attracted to man, that is considered to be his privacy issue, and he can enter into that kind of a sexual activity the way he thinks he gets the maximum satisfaction. That's my lord, broadly, my wordings may not be accurate or my lord may be proper also. That's that Navtet Johar. Lord, kindly visualize a situation after 5 years down the line, based on this very thing, that from the beginning, I am attracted to those persons who are mentioned in the degrees of prohibited relationship. Incest is not uncommon in the world, and world over incest is prohibited. That I am attracted to my sister, I get, we are consenting adults, we are entering into activities within the privacy, and we claim our right of autonomy, our right of choice, and our right of doing something in private domain. Based on that very argument, my lord, I'm posing a question to myself. Can someone not challenge this definition itself? Why this restriction? Who are you to decide with whom I have my sexual orientation? It may be, my lord, a little far-fetched.
That would be far-fetched.
Lord, we used to treat
reasonable restriction. You can't have.
We used to treat even this as far-fetched.
But Mr. Solicitor, sexual orientation or your autonomy as an individual can never be exercised. All aspects of marriage, including the entry into marriage, the prohibited relationships, the grounds on which marriage can be dissolved, these are all subject to regulation by law. So it may be very far-fetched for anybody to even argue before us that orientation is so absolute that I can therefore commit an act of incest. No court will ever.
But suppose polygamous marriage.
Get about sanctifying it, even
somebody can challenge, my lord, the bigamy
polygamous marriage, that's again governed by personal law, right? On the
I'm not on personal law. I'm saying, my lord, if I say that my choice is polygamy, the state has no right to it.
Your argument perhaps could be more, I would say, if you're leading up to that, one can understand it. But these are universal rules. I think we can all agree that these are universal rules. Now, as long as they were not codified, they were accepted. And that was the law, that was the norm. That they had a normative effect. Why did the state get into it? The state thought this as a universal norm. Now, therefore, I think if you're building up and saying there is a state interest in this relationship, one can understand. What if you're driving at that this is where the state comes in?
But that's my submission.
I think their position too was conceded, that when it comes to age also, that there is a state interest. So there is no field which is completely autonomous in that sense.
Okay.
Even within the marriage bond, there are certain interests of the state which are legitimate, let us say.
That is, in the second limb of my submission is going to be that state has no business to regulate social personal relationships. It is only in exceptional cases where the state...
That would be also very an extreme statement of law. If they have made that statement...
I'm saying something else. I'll just complete that. State has no business as a proposition to regulate any social personal relationship. That statement your lordships are saying is not it's an absolute statement. But I'm on an extension of that statement, that the state can regulate certain relationships if the state feels that it's in legitimate state interest to do so.
But of course,
therefore, marriage was not a regulated social relationship. But the state, in its legislative policy wisdom, decided that we will regulate, and we can regulate only if we recognize, and therefore under the Hindu Marriage Act or any other marriage act, we recognized and regulated.